Okay, hello class, and this is a video about the judicial branch. So I want you to follow along with your paper copy of the judicial branch PowerPoint. I've had some technical difficulties, so I'm not going to have it showing on my computer next to me as I talk about it. But so start on page 1, that's the title page. And this is the last of the 3 branches that we're going to study that was created in the Constitution to create the 3 branches of the federal government. So the judicial branch, it was created by Article 3 of the Constitution. So turn to page 2, and there's a picture there of a woman holding a scale and a sword, and she's got a blindfold on her. And the question for you to think about is, what does she symbolize? To help your thinking on that, she symbolizes, or what she is called, this woman, is Lady Justice. And she's got a scale of justice there. And you see how the scales are evenly balanced? And that is to indicate that when applying the law in this country toward individuals, whether it be a criminal law or a civil law, and we'll talk more about what the distinction is between those two is, everyone is treated equally before the law. It doesn't matter if you're young, old, man or woman, what your bank account is, or what color your skin is. Everyone's treated equally before the law. So the reason for the blindfold is that that's to indicate that justice is blind. It doesn't matter who it's being applied to. It's to be, ideally at least, applied equally to everyone, regardless of what they look like or whatnot. And then the sword is for enforcement. That we are considered a nation of laws, where the government, Congress, and the president pass laws, and the president's job is to enforce those laws, and people are expected to follow those. And then there are consequences that the judicial system gives out for breaking those laws. Okay, so let's go to page 3. So what is the role of the judicial branch? Its primary job is to interpret the laws that Congress has passed and that the executive branch enforces. And why do they need to be interpreted? Well, sometimes words aren't always very clear, especially when they are to be applied in many different types of situations. So what the job of the judicial branch is to, in every different situation or disagreement that people have that they bring to the courts to decide, the courts apply the law to a given situation and decide, make a decision about who's right and who's wrong, okay? And remember, because we have a system of federalism in our country with 50 states that all have their own state governments, that also applies in the federal judicial system. So there is a federal system of federal courts, and we'll talk about what that consists of. But every state also has its own state courts. Just like every state has its own legislature, which is equivalent to Congress, which passes state laws that apply in their particular state. So then if a state law is broken or allegedly broken by someone, the dispute would be heard by a state court. Okay, so let's go to number 4. And we've already talked about that Article 3 of the Constitution creates the judicial system. But what Article 3 actually creates is only one court, the U.S. Supreme Court, okay? And that's the highest court in the federal judicial system. And then Article 3 says that Congress has the power to create any lower federal courts that it deems necessary. And Congress has created quite a few additional courts in the federal system in addition to the U.S. Supreme Court. So turn to page 5, and so there it asks, how do judges get their jobs? Well, according to Article 2, which deals with the executive branch, it gives to the President of the United States the power to appoint all federal judges, not just the judges of the U.S. Supreme Court, but all of the lower federal courts that Congress has since created. And the one caveat to that, or check and balance on the president's power to appoint federal judges, is that the Senate, just the Senate, not both houses of Congress, has to approve every single federal judge appointed by the president. Okay? And then it asks the question, what does the Constitution say about qualifications for judges? Well, if you read Article 3, which you've done when you outline the Constitution, you know that there are no qualifications set forth in the Constitution for judges, unlike qualifications for being president or being a member of Congress. So a federal judge presumably has to be an adult, but there's no requirement that they have gone to law school or have been a judge before, although there are no I think state or federal judges that have not graduated from law school as a practical matter. But the Constitution does not require it. Okay? So let's go to number 6. And that talks about how the president's appointment of federal judges is really quite a political process, and the approval by the Senate is quite political. And we saw a good example of that if you watched any of the hearings before the Senate Judiciary Committee last fall, when President Trump's appointment of Brett Kavanaugh was reviewed by the Senate Judiciary Committee and then ultimately approved, but I think the vote was 51-49 on Kavanaugh's approval. So, and I think the vote was pretty much along party lines, split Republican, Democrat. So it's a pretty political process. As far as what is the term of office for federal judges, as you know, federal judges are appointed for life. They can stay in their job for life as long as they have, quote, good behavior. There have been, I think, about 17 judges that have been impeached by the House of Representatives and then tried and convicted by the Senate and removed from office for various types of bad behavior. But other than that, a judge can serve as long as they want. And oftentimes, especially on the U.S. Supreme Court, they serve until they die. Sometimes they retire before they die, but oftentimes they serve as judges well into their 80s. And we'll see a few of those that are quite old currently on the U.S. Supreme Court. Okay, so let's turn to page 7. So under our system of checks and balances and separation of powers, the framers of the Constitution viewed the federal judiciary as a real check on the power of Congress in passing laws and on the executive branch in enforcing them. So what is the judicial branch's power? Because the judicial branch does not have an army to enforce its decisions. When it makes a ruling, it issues them, but it has no power of its own to enforce those decisions. It has to rely upon the executive branch to enforce those decisions, and sometimes the executive branch has ignored them. So the federal judiciary basically has the power of public opinion and prestige behind it as far as a way of enforcing its decisions. As I said, if we turn to page 8, we have what's called a dual court system under our federalist system in our country. So we have a federal court system, and then each state has its own set of state courts. And that's but we're going to just focus on the federal court system. And if you turn to page 9, there's a diagram there. So you've got the U.S. Supreme Court as the highest court, And then if you look on the left side, there are 13 courts of appeals and then 94 federal district courts. And you can just ignore the other rest of that diagram for now. So if you go to page 10, it describes those three levels of the federal court system. The district courts are where trials are held in the federal court system. And then if the losing party does not like the district court's decision, it can appeal that decision to one of the 13 courts of appeal, which then reviews what the federal district court did and then makes a decision either to sustain or uphold the district court's decision, or to overturn it and send, if the Court of Appeals overturns the decision, usually what happens is the case goes back to the district court for a retrial of the matter, a new trial. If a party does not like the Court of Appeals decision, it can appeal to the U.S. Supreme Court. And we'll talk about the U.S. Supreme Court more in detail in just a minute. Let's go to page 11. That, again, is a depiction of the three levels of the federal court system. And you can see at the district court level, there are 94 district courts. There are 3 in Minnesota, 1 in St. Paul, 1 in Minneapolis, and 1 in Duluth. And at each district court, there's only 1 judge. Okay? And then at the Court of Appeals, you can go to page 12 and see a map there of the districts for the Court of Appeals. And you'll see that Minnesota is in the 8th district, or the 8th Circuit Court of Appeal. They're called circuits rather than districts. So the Court of Appeals for the 8th Circuit is located in St. Louis, Missouri. And if a party appeals a case to a Court of Appeals, the case will be heard by a panel of 3 judges. And then at the highest level, the U.S. Supreme Court currently has 9 judges on it. And you can see they're all uneven numbers, because then you get a decision that's not a tie. Okay? So now let's turn to page 13, and that talks about jurisdiction. What kinds of cases? Jurisdiction, as you know, means authority. What kinds of cases do federal courts have authority to hear? And you'll see those listed on page 14. And there are 2 categories of types of cases. One, depending on what the subject of the case involves, and 2, depending on who the parties are involved in the case. So let's look at subject matter first. And if the case involves an issue arising under the U.S. Constitution, like a free speech issue or a right to bear arms issue, it would be heard by a federal court. If the case involved an issue under a federal law, it would be heard in federal court. And if it involves a claim against a foreign government, it would be heard in federal court. And then under the types of parties that are involved, if the case involves the United States government as a party, the U.S. government, believe it or not, can be sued either by an individual or by a state. If the case involves a dispute between 2 separate states, say Minnesota decided to sue Wisconsin over some dispute, that would be heard in federal court. Or if the case involved citizens of 2 different states. So let's say a person in Minnesota had a dispute with someone living in Montana. That case would be heard in federal court. Okay? So those are the 6 types of cases that federal courts have jurisdiction or authority to hear. All other types of cases can only be brought in a state court. Okay, so let's see. Let's turn to page 17, and we're going to now talk about the concept of judicial review. What is judicial review? And that is the power to declare a law to determine whether a law violates the U.S. Constitution. And that power of the judicial branch is not set forth in the Constitution, but it was established in an early case that the U.S. Supreme Court heard, and it was a case called Marbury versus Madison. And pages 18, 19, 20, and 21 talk about that case. But basically what that case said is the Supreme Court said that we, even though this is not set forth in the Constitution, we, the U.S. Supreme Court, has the power to decide whether a law conforms with or violates the U.S. Constitution. Because you know that the Supremacy Clause in the Constitution says that the U.S. Constitution is the supreme law of the land. So no federal law or a state law can be in conflict or violate the Constitution. And if the U.S. Supreme Court decides that a federal law or a state law does violate some provision of the Constitution, the Supreme Court has the power, as decided by Marbury versus Madison, to strike it down. And if it strikes down the law, then it is just eliminated as a law. So that's a very powerful check that the judicial branch has on the power of the executive and legislative branches. And that is the power of judicial review. So that's a very important concept to keep in mind. So now let's talk specifically about the U.S. Supreme Court. So turn to page 22, and there's a picture of the U.S. Supreme Court building in Washington, D.C. It's just across the street, kitty corner from the U.S. Capitol. So, and you can go and visit there and go in and sit and hear cases being heard by the U.S. Supreme Court when they are in session. And sessions of the U.S. Supreme Court typically start at the beginning of October and run through about the end of June. And then they take the rest of the time off as vacation. But they work pretty hard during the months that they are in session. So let's turn to page 23. And the U.S. Supreme Court is known as the court of last resort. What does that mean? It means that if you appeal to the U.S. Supreme Court and your case is heard and decided and you don't like the U.S. Supreme Court's decision, it's too bad. You have to live with it. There is no other place to go to try to get a different decision, okay? So it's the last resort. Okay, and it says, what are the judges on the Supreme Court called? All other federal judges except the judges on the U.S. Supreme Court are called judges, but the 9 judges of the U.S. Supreme Court are called justices. And the leader of the U.S. Supreme Court is called the Chief Justice. And then the other 8 justices are called associate justices. So go to page 24. And the Supreme Court is the only court that does not have to take every case that is appealed to it. The 2 lower levels of the federal system, they have to take cases that are brought to them. But the U.S. Supreme Court gets to pick and choose. And you'll see for a minute why that's essential. Because there's only one U.S. Supreme Court and they only have so much time. So they get to pick and choose. So in order for a case, if you're at the Court of Appeals and you don't like their decision, you have to petition the U.S. Supreme Court, which means to ask the court to take your case and review it. And if the Supreme Court, they meet and they look at all the petitions asking them to review a case, and they discuss each one, and then they vote. And if 4 of the 9 justices think that the U.S. Supreme Court should take a case and review it, that's called the Rule of 4, then the Supreme Court will issue a writ of certiorari. That's a Latin term, and it means acceptance of a case. Okay? And then that goes to the parties in the case, and they say, yes, we will take your case for review. Okay? So let's go to page 25 that talks about the process at the Supreme Court. The court's term starts, it says there, the first Monday in October, and it goes through about the end of June of the next year. The Supreme Court sets the exact date. And if a case is accepted for review and the court has issued a writ of certiorari to the parties, then the parties will each file a written document called a brief. And it's setting out their legal arguments why the case should be decided in their favor. Either overturn the lower court's decision or confirm it, agree with it. And if there are other parties sometimes that are not part of the case, but other entities or individuals out there that have a strong interest in a case, they can file a petition asking the court if they too can file a brief in the case. And if the court grants that permission, then these other entities that are not part of the case, parties to the case, can file what's called an amicus curiae brief. That's another Latin term. And it's what it means is friend of the court brief. So then the court will read all of the briefs that are sent to it, as well as a transcript of the decision of the lower court's ruling. And then there will be an oral argument where one lawyer for each side gets 30 minutes each to present their arguments verbally before the U.S. Supreme Court. And during those 30 minutes, each of the justices can ask as many questions of each lawyer as they want to. And those are the oral arguments that you can listen to if you go to Washington at the U.S. Supreme Court building. And then if you turn to page 26, after the oral arguments are held, the justices will meet together and discuss the case and then ultimately vote. And it does not have to be a unanimous decision. It could be 5-4, 6-3, 7-2, 8-1, or 9-0 if it is unanimous. So let's say there's a 6-3 decision. So then the Chief Justice will choose one of the justices that's in the majority, that one of the six, to write the court's opinion. And then that opinion is circulated amongst the other justices for review before it is issued. And then the justices, like the 3 in the 6-3 decision, that disagreed with the majority, any one of them can issue their own separate opinion, disagreeing with the majority's ruling. And those opinions are called dissenting opinions, where they dissent or disagree. But the majority opinion then is issued to the public, and that becomes the court's ruling, and that's legally binding on all federal and state courts in the United States. Okay? So let's turn to page 28, and that gives you, there's a table that lists the over the years from 1950 through 2020, the number of cases that have been brought to the lowest level, the district courts, and the number of judges at the district court, and then the number of cases that have been appealed in each of those years to the Court of Appeals, and the number of Court of Appeals judges. And you can see how it has grown just incredibly over the last 60 or 70 years. And then if you look at page 29, you can see how many cases have been petitioned to the U.S. Supreme Court for review. And the tall bars is the total number of cases that people have asked the court to review, and then the very small bar are the number of cases in each of those years that the Supreme Court has accepted for review. So you can see it's a very small, it's just a couple of percentage of the total cases that are brought to the U.S. Supreme Court that the court actually accepts. So it's very, very difficult to get your case heard by the U.S. Supreme Court. And then if you go to page 30, you can see there's a graph there that shows the types of cases that have been brought in federal court from 1970 through about 2005. And it distinguishes between criminal cases and civil cases. And you can see that criminal cases have really skyrocketed. And criminal cases are cases involving alleged violations of criminal laws or crimes. And then civil cases are just all other types of disputes between individuals or companies or states, any kind of if someone feels that someone has broken a contract that they've had with another company, or violated a patent, or maybe damaged their property, anything like that. So now the rest of the pages really examine the current makeup of the U.S. Supreme Court. So there's a picture of the current U.S. Supreme Court on page 31. On page 32, it tells a little bit about each of the 9 justices. And then on pages 33 through 41, there's one individual slide that talks about each of them individually, how old they are, who they were appointed by. You can see on page 33 is Chief Justice John Roberts. He's the head of the Supreme Court. And then, as you can see, we currently have 3 of the 9 justices are women. The youngest justice is the one who was just appointed on page 41, Brett Kavanaugh. And then the other justice that was most recently appointed, both by President Trump, on page 40 is Neil Gorsuch. And as a result of those 2 appointments, the U.S. Supreme Court has really tipped much more conservative than it was previously. The oldest justice currently on the Supreme Court is Ruth Bader Ginsburg. She's depicted on page 35, and she is 84 years old. And there's some indications she's in some poor health, so she may be retiring, but she is a very liberal justice, and I think she's going to try and hold on as long as she possibly can through President Trump's presidency. So I hope that gives you a little overview of the judicial branch. Good luck and on the last few assignments in the course. Thanks.